Start. You wrote geography test today?
You should become more answers.
I mean, it is written or what?
One more answer should be right. We can, after class, we should be.
Prelims that's means one question are written, the other question is pending.
Okay. Oh, for mains also they gave questions. Tomorrow 40 questions. Okay. How much do you need? 40 minutes?
Most are possible.
Take 40 minutes. Okay. It's okay. Take 40 minutes. When will you write? After lunch?
After lunch, no time, sir.
Huh?
Morning only.
Morning or late, right? Alright. Where did we stop? Like budget, no?
Contingency for contingency.
Huh? Contingency fund, right? Yeah. Finance bill, everything is done, right? Yeah. Okay. So we started with, Friday. Where did we start? Started.
Like legislative procedure in the parliament.
Parliament, right? What are the three types of bills?
Ordinary bill.
Yeah.
and,
Finance bill,
Finance bill.
then constitutional amendment bill, right? What is the majority required to pass an ordinary bill? Simple majority, right? So what is the legislative procedure for ordinary bill? It can be introduced either House of Parliament, by a minister or by a private member, right? Then if there is a disagreement between both the houses, or if the second house does not take any action for how many months? 6 months. Then, or the first house rejects the amendment proposed by the second house, then president will notify what? Joint sitting, right? What is the? Who is the presiding officer of joint sitting?
Speaker.
Speaker of Lok Sabha. In his absence?
Deputy Speaker.
In his absence?
Deputy Speaker of Parliament.
Deputy Chairman of
Deputy Chair.
Rajya Sabha. In his absence, any member
From both
taken
houses.
from both houses, any one of the members chosen by themselves, right? Who is Speaker pro tem? Speaker pro tem.
7 years, senior leader.
Yeah. What is his? Who he is appointed by?
President till the term of newly elected person.
Yeah. To prescribe both to conduct the election of the new speaker, right? Fine. Then money bill. Which article deals with money bill?
150.
Article 110, right? So, what is the procedure for money bill? Where it can be introduced?
Only in Lok Sabha.
Only Lok Sabha and only by a
Taken permission from the president.
prior permission of the president, one thing,
Only
and
minister.
only the minister, because it is always a government bill, right? It can never be a private bill, right? Okay. Then Rajya Sabha, within how many days it has to return it?
14
Within 14 days. It can only make
amendments.
recommendations, not amendments. It cannot make amendments. It can only make recommendations. Within 14 days, it has to return the bill to the Lok Sabha. Otherwise, the bill is considered passed by both the houses. Who decides the bill is money bill or not? Speaker of Lok Sabha. And his decision is not subject to judicial review. It is free from judicial review. Right? Then, Finance Bill Type 1. Which article deals with Finance Bill Type 1? 117, Clause 1. Right? Then, Finance Bill Type 2. 117, Clause 3. Right? Constitution Amendment Bill 368.
168. 168. Article 168.
Deals with what?
Constitution amendment.
No, Article 368. I told 168?
Yes.
You must have written 168. It is Article 368.
In exam we wrote 368 only.
Yeah. I got shocked, man. Where is this 160? 360. Okay, correct. Article 360 deals with Constitution Amendment Act. Amendment procedure of the Constitution. Okay. So what is the procedure? The bill can be introduced either by a minister or by a private member. It can be introduced only in Lok Sabha. No, it can be introduced in either house of the parliament. Then what is the majority required?
Special majority.
Special majority. Right? Giant sitting is allowed for constitutional amendment bill or not? Giant sitting.
No constitutional convention.
No, because both the houses will have to pass the bill separately. Right? Both Lok Sabha and Rajya Sabha has to pass the bill separately. There is no provision of joint sitting for constitutional amendment bill. Right? It is available only for ordinary bill, finance bill type 1 and finance bill type 2. For money bill as well as for constitutional amendment bill, there is no provision of joint sitting. Then what we did?
Amendment of the Constitution.
Amendment of the Constitution. What are the three types of amendments?
Simple majority.
One can be done through simple majority of the parliament, that is outside the ambit of Article 368. Then special majority of the parliament, and special majority in parliament and simple majority in
State.
state legislative, half of the, at least minimum half of the state legislative assemblies, need not to be all. The moment half of the states approves the bill with simple majority, then it can be referred to president for his assent. Alright, fine. Then first reading, second reading, third reading, all done, right? Then what do you mean by vote on account? I mean, which article deals with budget?
112.
112. Our constitution calls budget as annual financial statement, right? So what is vote on account?
1/6 of the budget.
Budget will be, I mean, permission from parliament will be taken, especially from Lok Sabha will be taken for to spend the money till the end of the budget is approved by the house, right? Till then they will take the permission of the house to spend money. That is vote on account. 1/6 of the total outlay of the budget, right? Then budget can be introduced in either house of the parliament or only in Lok Sabha. Only in Lok Sabha, because budget is a money bill, right? Rajya Sabha can only make recommendations. It cannot vote on demand for grants. Demand after voted by Lok Sabha, it becomes grants, right? So before introducing budget, the previous permission or recommendation of the president is needed, right? Then only it can be introduced in Lok Sabha. Who will introduce it? It is the finance minister. It is always the finance minister, right? In sometimes in state like Karnataka, the chief minister only will hold the finance department ministry. At that case, it is the chief minister, as he has the he is the that portfolio is kept by chief minister. Then chief minister will introduce budget, right? Otherwise, it is the minister who holds the finance ministry will introduce the budget in the house, right? Fine. Then what are the three types of funds we have?
Consolidated.
Consolidated fund of India, public accounts, contingency fund of India. Article
266.
266, 267. To spend money from consolidated fund of India, the approval of what are the two types of expenditures? No, that is from economic. Charged. What are the two types of expenditures from consolidated fund of India? Expenditure charged upon the consolidated fund of India. Expenditure made. What is the difference between those two?
Charge is, it does not require any fund.
It is not subject to vote of the parliament, whereas made is subject to vote of the parliament, like salaries of Supreme Court judges, pensions of the High Court judges, then salary allowances of Union Public Service Commission, salaries of president, vice president, speaker, deputy speaker, right? Election commission, chairman, I mean chief election commissioner, other election commissioner salaries, allowances, all those things are charged upon the consolidated fund of India, whereas other expenditures are made from the consolidated fund of India, right? Then for public accounts is dealt by executive orders, right? Contingency fund of India is under the disposal of
President.
president, right? But actually it is the finance secretary who will handle it, and it is not required to get the permission of the parliament when before spending, right? Post spending, the approval of the parliament is needed, right? Fine. We have seen one in all the notes. We have seen whose signature it will be there, no? Not president. In your 100 rupees notes, whose signature?
Governor RBI.
Governor of RBI, right? But in 1 rupee note, whose signature will be there? Yeah, 1 rupee. Whose signature? In India, it is the finance secretary. Secretary of finance, finance secretary. It is actually 1 rupee notes and coins are printed by Government of India. Other notes are printed by RBI. In all the notes, it will be the signature of RBI governor. I don't know whether you have seen or not. In old notes, no, there used to be signature of Manmohan Singh.
And Ujit Patel.
Yeah, Ujit Patel, yeah, he was a governor. Before that, Manmohan Singh was RBI governor. In old notes, you used to see his signature. When we were in school and all, when he was prime minister in 2004, 5 and all, that time we used to get old notes. No? In that it used to have Manmohan Singh signature, as he was a governor of Reserve Bank.
So as people changes in the signature, it keeps changing so on and off.
New note. Old note, no one can change, no. So in new notes, they will change. Who is the next governor? I mean, present governor will be there, no? During his term, if any new notes are printed, then his signature will be there. Right? Fine. Then, yeah, how many departmental committees will be there to scrutinize the budget? 24 departmental committees having 31 members. 21 from Lok Sabha, 10 from Rajya Sabha. Right? Fine. There are various departmental committees, parliamentary committees. I'll explain what it is. Rest, all the numbers, facts and all, you'll have to go through it. Okay, there is nothing to explain. Just when you read it, you will get to know. Because different committees has different numbers. There are estimates committee, public accounts committee, all those committees. Just go through it. Okay. There is nothing much to remember. What you have to remember is, there are some important committees like public accounts committee. There is something called estimates committee, which has only members from Lok Sabha. There won't be any member from Rajya Sabha. Those kind of things you have to remember. Okay. Fine. So we did demand for grants. Okay. Consolidated Fund of India. Okay. Okay. Then legislative powers and functions of Parliament. Legislative powers and functions of Parliament. Legislative powers and functions of Parliament. This is what we did, no? Parliament can make laws on, there is something called central-state relations. I will do some other part there. Parliament, just understand this. Parliament can make laws on the matters which are in the union list. I told you the 4th schedule deals with allocation of seats in Rajya Sabha. 7th schedule deals with subjects, division of the subjects. Right? There are 3 lists: union list, concurrent list, state list. Right? So union list, state list and concurrent list. So Parliament has power to make laws on union list, right? And it can make laws on concurrent list. Parliament can make laws on union list as well as concurrent list. What happens if concurrent list? What do you mean by concurrent list? It is on the subjects. Why the subjects were divided into 3 lists? See, on those matters where there is a uniformity required throughout India, You're getting my point, right? There are some matters on which the uniformity is required throughout India. Defense. Getting my point, right? External affairs. On those things, it is only the parliament can make laws. There are subjects on those uniformity is not necessary. Right? State can form their own laws. It is left to the state list. Then there are matters, uniformity is not always necessary, but sometimes it is necessary. In those matters which are kept in concurrent list. Got my point, right? So on union list, parliament alone can make laws. On state list, in normal circumstances, state government alone can make laws. Normal circumstances. There are circumstances where the parliament can also make laws. I will tell you during emergencies and center-state relations. Okay. Then there is concurrent list where both state and central can make law. What happens in if there is a conflict between those? I will tell you during national center-state relations. Okay. So, and we are talking about powers and functions of legislative powers, where parliament can make law on state list. Where when it can make laws on state list. One during national emergency, right? When Rajya Sabha passes a resolution, right? When two or more states makes a request, okay? When there is a president rule in the state. Next one is to give effect to any international treaty. You want to write it down? Fine. When Rajya Sabha passes a resolution, when Rajya Sabha passes a resolution, when Rajya Sabha passes a resolution, then the parliament can make laws on state subjects. When there is a national emergency, when Rajya Sabha passes a resolution, when there is a national emergency, second one. Third one, when two or more states makes a request, then the parliament can make laws on state subject only confined to those states which have made request. When two or more states makes a request, then to give effect to any international treaties, to give effect to any international treaties, to give effect to any international treaties, then during president rule in a particular state, during president rule, during president rule. Okay. When Rajya Sabha passes a resolution during national emergency, and when two or more states makes a request to give effect to any international treaty, when there is a president rule, then parliament can make laws on state subject. Okay. So fine. Next, executive powers. It is nothing new. Okay. Whatever I have taught till now, I am just making a list of all those things. That's all. Right. Executive powers and functions of parliament. Council of ministers can be removed from the office. Right? The council of ministers can be removed from office by who? Lok Sabha or Rajya Sabha? The council of ministers can be removed from office by who? Who can remove? No confidence motion can be introduced in which house?
Both.
In both.
Lok
Lok Sabha only, right? In Rajya Sabha you cannot know. Rajya Sabha does not have members who are directly elected by people.
Only president can be removed.
Yeah. I am talking about government.
Government
Council of Ministers, it is only Lok Sabha. No confidence motion can be introduced only in Lok Sabha. And our constitution does not have provision saying that no confidence motion. There is nothing written called no confidence. It is not a constitution. In constitution, the word no confidence motion is not being given. Okay, it says that Article 74 says that they are collectively responsible to the. Sorry, Article 75 says that the members are collectively, Council of Ministers are collectively accountable to the Lok Sabha. Using that provision, NCM will be introduced. Right? As per the constitution, it has no mention of no confidence motion. Okay? Fine. The Council of Ministers can be removed from office by Lok Sabha. Then, I've written that. Next one is constituent powers. Constituent powers. Constituent powers. Simple. Parliament has power to amend the constitution. Right? The Parliament can amend the constitution under article which are 368. You should remember article. If you are studying polity means article you must know. For everything like for prelims, mains or whatever exams you will be preparing, you must know articles. Right? I told you na, before in front of your study, make such kind of sheets. Take one A2 sheet or A3 sheets, write down articles in import, at least 50 to 60 import articles. Every day, just go through it once. Don't try to remember it, just read it. If you read 20, 30 times, automatically you will remember it. Right? Do it. Otherwise, polity will be like, you feel it is very difficult. Right? If you know articles, subject will become easy for you. Right? Fine. Next one is judicial powers. Judicial powers. Judicial powers. Impeachment of judges of Supreme Court and High Court. How to do that? I'll explain it in Supreme Court and High Court. Impeachment of judges of both Supreme Court and High Court will be done by who? Parliament. Both Lok Sabha and Rajya Sabha. Parliament. Okay. Then removal of the president. Removal of the president. Removal of the vice president. Okay. Fine. Next, we will compare Rajya Sabha and Lok Sabha. Okay. Comparison between Rajya Sabha and Lok Sabha. Now you should only tell this thing. First one is where it is unequal status with Lok Sabha. Where Rajya Sabha is unequal with Lok Sabha. We are comparing the powers of Lok Sabha and Rajya Sabha. Where Rajya Sabha is unequal with Lok Sabha. Unequal with Lok Sabha. Where? Very good. First one is introduction and passage of the money bill. Right, you can write it down later. We'll discuss it. Okay. Later I'll dictate it. We just write it down then. Okay. First one is where? Money bill. Money bill can be introduced only in Lok Sabha. It cannot be introduced in Rajya Sabha. Then Lok Sabha is more powerful there. Right? Next one. Just now we discussed one.
People directly elected.
Yeah, what is that? No confidence motion. That can be introduced only in Lok Sabha, not in Rajya Sabha. Then you can write it on, I dictate it. Okay. Then finance bill type 1. That can be introduced only in Lok Sabha, not in Rajya Sabha. No confidence motion, I told her. Yeah, that can be introduced only in Lok Sabha, not in Rajya Sabha. Then money bill, then no. Then where? Budget. Budget, it is nothing but money bill. It can be discussed by Rajya Sabha, but Lok Sabha has the power to amend it or reject it. Right? Then the joint sitting will be done based on the rules of the procedure of Lok Sabha, not Rajya Sabha. Right? Fine. If you want to write it, I'll dictate it. So first one is money bill. Just write money bill. We are talking about, because the details you have read before only, na? You know what it is. Where Rajya Sabha is unequal with Lok Sabha, means where Lok Sabha has more powers. Right? One, money bill. Second one, finance bill type 1. Right? Then the final power to decide whether a bill is money bill or not is with whom? Speaker of Lok Sabha, and its decision is final. It is not subject to judicial review. Right? First one is money bill. Second one, finance bill type 1. Third one, final power to decide whether a bill is money bill or not. Final power to decide whether a bill is money bill or not is lies with Speaker of Lok Sabha. Then joint sitting is presided over by Lok Sabha Speaker. Joint sitting is presided over by Lok Sabha Speaker. Final power to decide whether a bill is money bill or not lies with Lok Sabha Speaker. Joint sitting is presided over by Lok Sabha Speaker. Then Rajya Sabha can only discuss budget. Then Rajya Sabha can only discuss budget. Then one more thing is there, but I have told you what national emergency is. Just write it down. Okay. Revocation of resolution for discontinuation of national emergency can only be passed in Lok Sabha. Resolution for discontinuation of national emergency can only be passed in Lok Sabha. Resolution for discontinuation of national emergency can only be passed in Lok Sabha. A resolution for discontinuation of national emergency can only be passed in Lok Sabha. Okay. Next, NC may have written, no? That is no confidence motion. Huh? Just write NCM, no confidence motion, that can be introduced only in Lok Sabha. Okay. Then, what is special powers of Rajya Sabha? Now, special powers of Rajya Sabha. Special powers of Rajya Sabha. First one is, it can allow Parliament to make laws on state subject. Rajya Sabha can allow Parliament to make laws on state subject under Article 249. Under Article 249. Rajya Sabha can allow Parliament to make laws on state subject. Can allow, sorry?
Article
249. Rajya Sabha can allow who? Parliament to make laws on state subjects. Okay. Okay. What is the exact provision? I will do it in center-state relations. There you have to read 249, 250, 252 and 253 articles. 4 articles. Whatever I told now, when Rajya Sabha passes a resolution during national emergency, when 2 or more states makes a request to give effect to international treaty, there are 4 articles in total. 249, 250, 253 and 252 and 253. Okay. I'll do it in center-state relations. Okay. So this is 249. While doing unequal status I told now, where Parliament can make laws on state states. One, Article 249 says that when Rajya Sabha passes a resolution. Article 250, when during national emergency. Article 252, 2 or more states makes a request. Then Parliament can make laws. Then Article 253 to give effect to international treaty. Okay, I'll do it later. So 249 you got it, no? What it says is, if Rajya Sabha passes a resolution with special majority, okay? If Rajya Sabha passes a resolution with special majority, then then Parliament can make laws on state subject. Parliament can make laws on state subject, and validity of such resolution is 1 year. Okay, validity of such resolution is 1 year. Means till the completion of 1 year, the Parliament can make laws on state subjects. Okay, validity of such resolution is 1 year. If the Rajya Sabha passes a resolution with special majority, then the then Parliament can make laws on state subjects. Understood, no? What I mean? See, if the Rajya Sabha decides that there is some state subject, okay? If the Rajya Sabha decides that we want to, we have to allow Parliament to make laws on that state subject, then Rajya Sabha passes a resolution. Such a resolution has to be supported with special majority. Then both Lok Sabha and Rajya Sabha together can make a law on that state subject, which is applicable to whole of India for a period of 1 year. Okay. After that it cannot make. After that, if it wants to make a law, then again the resolution has to be passed in Rajya Sabha. Understood? Clear? Fine. So next one is creation of All India services. Sorry? Should be connected, huh? It is for mic, no? It is for mic only, right? Then till now whatever I taught. Then why this one is for what? No, this one is for what?
That is on the mic.
Yeah, what is this then?
That is receiver, sir. Whatever you tell,
Okay.
can be clearly audible to the people.
Till now, whatever I have done,
Yeah, they can hear, but not.
yeah, it won't be clear. Yeah, whatever phones might capture, no, that much will be right. So creation of R&D services. How many R&D services we have?
3.
What are those? IPS and IFS, Indian Forest Service. Rest are central services, right? Article 312 is only R&D services can be created by the resolution of Rajya Sabha. It empowers Rajya Sabha to pass a resolution to create All India services. All India services. Okay, simple. If the Rajya Sabha passes a resolution, then it empowers Parliament to create new All India services. There are demand like health service and judicial service kind of services needs to be created, but till now earlier we had only 2 All India services, IAS and IPS. I think in 1971 or somewhere they created a new All India service, that is IFS. Till now we had only 2. Till then we had only 2. Okay, fine. Then there is one more thing. Rajya Sabha has special power with respect to Vice President. What is it? Related to Vice President, Rajya Sabha has a special power. What is it? What? What is it? Removal of Vice President. The resolution can be introduced only in Rajya Sabha. Right? Then it has to be supported by absolute majority. Then Lok Sabha, simple majority. I told you, na? Removal of the Vice President, resolution can be introduced only where? Rajya Sabha. You guys didn't read anything in last 2 days? How are you writing test tomorrow then? Huh? You what book? Then what you will study tomorrow? And you have asked me to give tough questions only. Study, man. At least revise it properly once today. Because it is not that much, no? At least study some 70% of the syllabus. Right? Okay. You should revise it. See, when you are in class, no, you feel like everything is easy. You are understanding everything, hey, this article, that article, everything I will do. But when you start reading, then only you will get to know. And when you start writing questions, then only you will get to know what is there in your mind. And unless you won't understand anything. And when it comes to mains, no, when you start writing answers, no, then only you will get to know that how to write an answer or what is your capacity. Otherwise, you will feel like I will give introduction, I will write, conclusion, body, everything I will write. But when you start writing, for introduction only, you will be stuck for 5 minutes. You start writing one answer, you will understand. Take one simple question from previous year UPSC or KPSC, KS mains papers. Try to write one answer. Just for UPSC, quality question only. Try to answer, you will start. How to start only a big question. When you start, it will go smoothly. But starting is like, that is a very difficult part of writing any answers. Giving a good introduction. Right? So start reading, otherwise it will be very difficult. I'll be, my syllabus will be, I'll be finishing this by Thursday. Worst case, it may go up to Friday. But by Thursday, I'll finish it. Then new subject will start, no? This will be pending only again. Once your all classes are done, no? Then you'll be having all subjects to read. That time you'll have to revise, that's all. Revision is the key for any competitive exams. For any competitive exams, revision is the key. Reading one source for 10 times is better than reading 10 sources one time. Right? So you should revise it, otherwise it will be very difficult to recall it. Here you will understand, okay, pardoning power is 72. There, no, you feel like it is whether it is 72 or 62. When you see the options, all doubts strike in there. Right? Revise it, whatever, how much you can, just revise it and write the test tomorrow. Simply don't write it. If you want time, take one more day time. If you can't write it tomorrow, at least write it day after tomorrow, but prepare and write. Simply just don't come and write. Okay? If you want, take one more day time. You can write it day after tomorrow as well. But at least read something and come. Okay? Fine. Yeah. Where it is special power? The resolution for Removal of vice president can be introduced only in Rajya Sabha, not in Lok Sabha. Right? Fine. Next one is where it is equal, where both Lok Sabha and Rajya Sabha are equal. Equal status, equal, where Rajya Sabha and Lok Sabha are equal. First one is ordinary bill. Correct, no? Correct, right? Ordinary bill can be introduced in either house of the parliament, right? Both Lok Sabha and Rajya Sabha, it can be introduced. Second one, what do you remember? Article 368. Constitutional amendment bills that can be introduced in either Lok Sabha or Rajya Sabha, and there is no provision of joint as well. So it is both the houses are equal. Constitutional amendment bill. Third one, finance bill type 2. Correct. Then removal of who? President. Good. Removal of president. Right? Then removal of judges. Judges of Supreme Court and High Court. Right? Removal of judges of Supreme Court and High Court. Then NCM. No confidence motion. Equal. No confidence motion is can be introduced in both Lok Sabha and Rajya Sabha.
No, sir.
No, right? It is not equal. It can be introduced only in Lok Sabha. Then selection of ministers and prime minister. Selection of prime minister and other ministers. Correct? No. They can be the member of either house of parliament. Correct? No. Selection of prime minister and other ministers. You can choose ministers, members of Rajya Sabha can also become ministers and prime minister. Even Lok Sabha members can also become prime minister and minister. No, there is no restriction saying that the prime minister needs to be from lower house only. There is no such thing in constitution. They can be a part of either house of the parliament. There it is equal, right? Clear? Then write this, just write it down. I'll explain it in national emergency. Approval and proclamation of 3 types of emergencies. Approval of proclamation of 3 types of emergencies. Approval of proclamation of 3 types of emergencies. Okay. Right. Then election of president. Correct? No. Election of president and vice president. Both houses have equal powers. Vice president. Then consideration of reports of constitutional bodies. Consideration of reports of constitutional bodies like UPSC, CAG. These reports, every year they will submit annual reports that can be considered by both houses. Consideration of reports of constitutional bodies. Okay. There is nothing to explain in this topic, but I hope you understood. It is just whatever we did in Parliament chapter, just gist of it, right? Whatever I told points, all those things we did before only, right? Just you need to arrange it where it is equal, where it is unequal, all those things. That's all, right? Okay. Next we will do Parliament. Sorry, Supreme Court. Court, I will do national emergencies, then we will go to state court. Finish state court. Anti-defection is done, right? Tension I am done, no? Supreme Court. So it is the, we have integrated judiciary, correct, no? Integrated judiciary. Supreme Court deals with which article? Article 124 to 147, 148 is CAG. Article 124 to 147 deals with Supreme Court of India, right? Fine. So we have integrated judiciary. What do you mean by integrated judiciary? There is no separate judiciary for state and center, correct? No, we don't have separate judiciary for state and center. We have integrated judiciary. Same courts will handle both state laws as well as central laws, right? So we have Supreme Court at the top. Below that there is High Court. Then there are district courts like Sessions Court, right? District courts. Then below there are different set of courts. City civil courts, taluk, JFMC courts, all those courts are there, no? Below subordinate courts. You can say below district courts, then below there are subordinate courts, right? So Supreme Court is at the top, that is the apex court, correct? There is only one Supreme Court in India. Then there are high courts. High courts, most of the states have high court. Some of the states have common high courts. For 2 states there is one high court, right? Fine. Then there is district courts and below courts. So we have integrated judiciary. There is no separate judiciary for state and center. Common courts, right? Fine. Fine. So next one, Article 124 to 147 of Part 5 deals with Supreme Court. Next one is organization of Supreme Court. Organization of Supreme Court. Supreme Court has Chief Justice or CJI, Chief Justice of India, plus 34 judges. Okay, 34 judges. CJI plus 34 judges. Okay, Chief Justice of India plus 34 judges. Who is the Chief Justice now? Gawai, right? He is the current CJ, Chief Justice of India. So the strength of the Supreme Court means how many judges should be there. Na? It is decided by the Act of the Parliament. Whereas in High Court, it is the President who will decide from time to time how many judges should be there. But in Supreme Court, it is the Parliament. Through an Act, decides the strength of Supreme Court. That is number of judges in the Supreme Court. Okay. Parliament can increase or decrease it. Okay. Clear? Fine. Then we'll talk about judges. Judges of Supreme Court. Who will appoint Supreme Court judges?
President.
It is the President. Okay. President will appoint judges of the Supreme Court. But it doesn't mean that President can appoint anyone as judge of the Supreme Court. It is based on the advice given by collegium consisting of CJI plus 4 senior most judges. Collegium consisting of CJI plus 4 senior most judges. These 4 senior most judges, this collegium means CJI plus 4 senior most judges was told by Supreme Court in third judge's case. Okay. In third judge's case, Supreme Court told that our constitution says that the president has to appoint judges in consultation with the CJI. Okay. In consultation with the CJI. In 2000 first judge's case, the Supreme Court told that it is just a consultation, not concurrence. What is the difference between consultation and concurrence? Yeah, very good. In consultation, there is exchange of views, whereas in concurrence, both he should obey the advice given by the CJI. In second judge's case, the Supreme Court told that it is not just consultation, it is concurrence. But in third judge's case, the Supreme Court told that it is not just the sole opinion of the CJI, it is the opinion of CJI plus 4 senior most judges. Got the difference, no? In first judge's case, the Supreme Court told that it is not concurrence, it is just consultation. In second judge's case, Supreme Court told that it is not consultation, the advice tendered by the CJI is binding. But in third judge's case, Supreme Court told that it is not just the opinion of the CJI. Getting my point, right? It is not just the sole opinion of the CJI, it is the opinion of the collegium consisting of Chief Justice of India, that is CJI, plus 4 senior most judges of the Supreme Court. CJI plus 4 senior most judges of the Supreme Court. So collegium means CJI plus 4 senior most judges. Okay. It is not just the sole opinion of the CJI. What in that judgment, Supreme Court told that even if 2 judges give adverse opinion, then the Chief Justice should not recommend that name to President. Okay. If out of 4, even if 2 judges give adverse opinion, the CJI cannot refer that name to President. Okay. Once the collegium refers names to President, that these are all the people who can be appointed as President, the President can appoint only those names. The President can buy the time, but he cannot reject them. He needs to appoint them, but there is no time bar within which he should appoint. That is why there is always a conflict between executive and judiciary. Right? Got the point? No? It is not just the President, but when there is a question, the Supreme Court judges are appointed by whom? It is President. Getting my point, right? Judges are appointed by President, but in consultation with the collegium. But the opinion tendered by collegium is binding. Okay? Clear? What is the minimum age to become the judge of the Supreme Court? Any idea? There is no minimum age. Okay? There is no minimum age to become the judge of the Supreme Court. What are the qualifications? The retirement age is 65 years. Age of retirement is 65 years. Okay. What are the qualifications? First thing is, they should have served as judge of High Court or consecutive High Courts for 5 years. Okay. They should have served judge of the High Court or consecutive High Courts for 5 years. Second one, they should have been an advocate of High Court or consecutive High Courts for 10 years. Third one is distinguished jurist. In the opinion of the President, there needs to be a distinguished jurist. Means the one who has knowledge of the law. Okay. So one distinguished needs to be a person in the opinion of President, a distinguished jurist. 2 things. Just remember, why I am stressing distinguished jurist, because for High Court that provision is not there. The distinguished jurist provision is only for Supreme Court. Okay. So first one, 5 simple words. 5 years, there needs to be a judge of High Court. Right? 5 years. Second one, conditions are this. Okay, both cannot be, need not to be achieved. Either they need to be a judge of high court for 5 years, or they need to be an advocate of any high court or successive high courts for 10 years. Third one is distinguished jurist. Okay, distinguished jurist in the opinion of the president. If all these three conditions are met, if any of these three conditions are met, then if the collegium recommended their name to president, then president can appoint them as judge of the Supreme Court. But there is no minimum age. Minimum age is not there. Okay, fine. One of my close friends' uncle is a judge of Supreme Court. If you heard name called Arvind Kumar, he was working in Karnataka High Court. From here, he got transferred to Gujarat High Court as CJ. From there, in 3 years ago, he got appointed as a judge of the Supreme Court. Recently, there was a Facebook post. His house name was written in Kannada in Delhi. His name in his house, it was written in Kannada. It was a more viral post. Yeah. So, what is the minimum age to become the judge of the Supreme Court? There is no bar, minimum age, right? Retirement age is 65 years. Next one is removal. Removal of the judges of the Supreme Court. Qualification is done, right? Yes. Right? Oath. Who will prescribe oath? It is the president. Right? It is the president. For High Court, it is governor of the concerned state. For Supreme Court judges, it is the president.
It's not Chief Justice.
No. President.
Will appointing the judge, right?
Sorry?
Will appointing the judge you're talking about, sir?
I didn't get you. Oath. It is the President of India. Okay. President or some person appointed by him. Okay. But actually it is President. In state high courts it is governor. It is not Chief Justice. No. It is the President. In the absence of President, any other person appointed by him. Okay. You have written Chief Justice. Huh? No. It is President. Okay. It is the President or any other person appointed by him. Okay. Fine. Then we are talking about what? Removal of judges. So resignation in removal only. Resignation to whom? It is President. The judges can give resignation to President of India. So removal, the President can remove a judge of a Supreme Court or Chief Justice of Supreme Court after receiving a resolution passed by Parliament. Okay. So President can remove the judge based on the resolution passed by Parliament. Okay. So what is the procedure? No, it is different. See, thing is, just understand this. Later on I will dictate it. You can write it down. So the removal for resolution of the President. Judges, Chief Justice or Judge of a Supreme Court. The same for the Supreme Court and High Court. Okay. So the resolution must be signed by 100 members in case of Lok Sabha, 50 members in case of Rajya Sabha. In President it is 1/4. Correct? No? 1/4 of the members of the House has to sign it while giving it to Speaker. Right? Here it is 100 members in case of Lok Sabha, 50 members in case of Rajya Sabha. If the resolution is moved in Rajya Sabha. Okay? Once it is being given to Speaker, the Speaker can accept it or he can reject it. He can reject the resolution or accept the resolution. Not Speaker, we can say presiding officer, either Lok Sabha or Rajya Sabha. If it is accepted, if the resolution is accepted, then a committee will be formed by the Speaker or Chairman in case of Rajya Sabha. The committee consisting of Chief Justice of India or a Judge of the Supreme Court, one person. Okay. Second one, Chief Justice of any High Court. Okay. Third one, a distinguished jurist. Clear? The committee will consist of 3 members. Chief Justice of India or any senior most judge of Supreme Court. The committee will be constituted by presiding officer of the House. Clear? And second one, Chief Justice of any High Court of the states. Third one, distinguished jurist. 3-member committee. Then committee will conduct inquiry and it will submit report to the speaker or presiding officer. If they found he is guilty, then the resolution will be moved in the House. Such resolution must be supported by special majority. Special majority, that is 2/3 of the members present and voting and majority of the total strength. What is in the case of a president? What majority is needed? To remove the president, what majority is needed in both the houses? Oh, this is the new thing you are telling. No. I told you that is the only one case you need a different kind of majority. That is only in removal of president you will find that majority.
2/3 of the total strength.
2/3 of the total strength. That's all. Stop there. Yes, sir. 2/3 of the total strength. That is only in removal of president you need 2/3 of the total strength. In any other cases you have, in no cases you have that majority. Only in removal of who? President you have 2/3 of the total strength. Removal of the judges you have 2/3 of the present and voting, and that should be greater than half of the total strength. That is majority of the total strength. Correct? No, that is special majority, right? This is the only case where while removing the president is the only case where you need 2/3 of the total strength. Here 2/3 of the present and voting and majority of the total strength. Understood now? So here we need special majority. What is the procedure? The resolution for removal must be signed by, you can write it down now. The resolution for the removal must be signed by 100 members in case of Lok Sabha, 50 members in case of Rajya Sabha. Then the resolution for the removal of presiding officer, judges of Chief Justice or Judge of Supreme Court must be signed by 100 members in case of at least 100 members in case of Lok Sabha, 50 members in case of Rajya Sabha. The presiding officer can reject it or accept it. The presiding officer can reject it or accept it. Presiding officer can reject it or accept it. Presiding officer can reject it or accept it. If accepted, then the presiding officer will form a committee. If accepted, the presiding officer will form a committee consisting of who? Presiding officer will form a committee consisting of
Chief Justice of India.
yes, Chief Justice of India or
High Court.
Chief Justice of India, Senior Most Judge of the Supreme Court. First person. Second person, Chief Justice of High Court. Third person, a distinguished jurist. Clear? The committee will be consisting of Chief Justice of India or Judge of the Supreme Court, then Chief Justice of High Court, then distinguished jurist. 3 members. Then committee will conduct inquiry and it will submit report to Speaker or Chairman in case of Rajya Sabha, if the resolution will be moved by Rajya Sabha. Then if the committee found them guilty, then resolution will be moved in the House. It has to be approved by what majority? Special majority. Special majority. Then the resolution will be passed to President and President will remove the judge. Alright? But till now, no Supreme Court judge has been removed. Because one time the resolution had moved, but it got failed in Rajya Sabha, I guess. It could not get the majority in Rajya Sabha. And before, in some 5 years ago, I guess, there was one more judge, the resolution was about to move, before that only he resigned. Currently, if you know, there is an issue going on in Yashwant Sharma, I guess, I forgot, Yashwant Verma. Ishwar Verma, the Delhi High Court judge. Some fire accident happened in his house, and this fire brigade went to clear that. That time they found crores of rupees in his what do you call that, outhouse. In his outhouse, in his official residence outhouse, they found crores of rupees. So now there is a resolution for his removal is under consideration in Rajya Sabha. The speaker has, the vice president, he was a chairman, he resigned, right? He accepted it. Now the proceedings has to start, right? So same procedure for High Court judge also same procedure. The procedure is yet to start, right? But till now no judge has been impeached so far. The procedure is called impeachment again. No judge has been impeached so far. Okay. Fine. Got the procedure, right? Fine. Remember what is the majority required. Okay. Fine. I spoke about qualification of judges, right? So while appointing CJ, it is in second judge's case, the Supreme Court told that the senior-most judge of the Supreme Court should be appointed as Chief Justice of India. Okay? There is no procedure, nothing. The senior-most judges will automatically, not automatically, it is binding on the President to appoint him as the Chief Justice of India. Okay? So earlier the provision was not there. That is why many a times, by bypassing the seniority, the judges were appointed. It became a controversy. In second judge's case, the Supreme Court told that it is the senior-most judge. He needs to be appointed as judge of the Supreme Court. That is why I told you Justice Nagaratna, she will become the next CJI. She will be the first woman CJI of India because she is in seniority, right? Like that. Fine. Okay. Then salaries and allowances. There is nothing much to write. I told you it is charged on the Consolidated Fund of India. That you think you should remember. That's all. What is their salary? That and all we don't bother. Okay. It is charged on the Consolidated Fund of India. When it comes to High Court, the salaries are charged on the Consolidated Fund of State, whereas pension is charged on the Consolidated Fund of India. When it comes to High Supreme Court judges, salary and pension both are charged on the Consolidated Fund of India. Okay. But there is one more condition. Once they are appointed, right, their salaries, allowances, it should not be reduced. Okay. Means it should not be changed on their disadvantage. It can be increased. After their appointment, it should not be changed, reduced. Okay. That provision is there in the Constitution. Okay. Fine. Next one is Acting Chief Justice. Acting Chief Justice. Who is Acting Chief Justice? When the office of the Chief Justice is vacant, then President can appoint one of the judges Acting Chief Justice. Okay. President can appoint one of the judges Acting Chief Justice. Okay. Then ad hoc judges. Ad hoc judges. Ad hoc judges. Ad hoc judges. What do you mean by ad hoc? Temporary judges, right? When there is no quorum in the house, quorum in the Supreme Court. When there is less number of judges, then the CJI can appoint a judge of the Supreme Court as a ad hoc judge of, a judge of the High Court as ad hoc judge of the Supreme Court. The CJI can appoint. It is not the President. The CJI can appoint the judge of the High Court as ad hoc judge of the Supreme Court for temporary period with the previous consent of the President or previous permission or consent of the President. When there is no quorum in the Supreme Court, then CJI can appoint a judge of the High Court who is qualified to be appointed as judge of Supreme Court. He should meet those qualifications, 5 years. That qualification should be fulfilled by him. Then he can appoint him as a judge of the Supreme Court. See, when Santosh Hegde, you know Santosh Hegde, right? You know Santosh Hegde? He was ex-Lokayukt of Karnataka. Ex-Lokayukt of Karnataka. He was not a judge of High Court or Supreme Court. He directly became a judge of Supreme Court. Sorry, he was not a judge of High Court. He directly became the judge of Supreme Court. I think he was the third judge or second one from in India who directly became the judge of Supreme Court. Getting my point, right? He never worked as a judge of High Court. From advocate, he directly became the Supreme Court judge. I think second or third. I don't remember exactly, but okay. Ad hoc judges you understood, right? Fine. Next, retired judges. retired judges, the Supreme Court CJ or Chief Justice of India CJ can request retired judges. The CJ can request the retired judge of Supreme Court or High Court to act as judge of Supreme Court with the previous permission of President. The retired judge of Supreme Court or High Court, the CJ can ask the retired judge of Supreme Court or High Court to act as judge of Supreme Court with the previous consent of the President. With the previous consent of the President. Okay? With the previous consent of the President. Then seat of the Supreme Court. Where is the seat of Supreme Court? New Delhi. Originally, I think after we got independence, no, it was in Parliament only. Current Central Hall is there in Parliament. In that part, it was Supreme Court, I guess. Later on, they built the current Supreme Court building and shifted our Supreme Court to there. Okay, fine. New Delhi is the seat of the Supreme Court. But our Constitution authorizes CJI to appoint any other place as the seat of the Supreme Court. Okay. Again, with the approval of the President. For everything, whatever CJI do, with approval of the President. Okay. Seat of the Supreme Court is New Delhi. The CJI can make other place as the seat of the Supreme Court with the approval of the President. Okay. CJI can make other place as the seat of the Supreme Court with approval of the President. Okay. Next one is independence of Supreme Court. Independence of fast ಅನಿಸ್ತಾ alright ನಿಮಗೆ ಹರ್ಷ fast ಅನಿಸ್ತಿದೆ ಇಲ್ಲಲ್ಲ independence of there is nothing to explain in these topics, that is why I'm just telling, right? Independence of Supreme Court. Fine. So first one is we are talking about what are the provisions are there in the Constitution to make the Supreme Court independent. Right? Judiciary needs to be independent. What do you mean by independent? It is free from any biases or any influences. Right? No one can influence Supreme Court. The country still has belief in our judicial system because it is independent body. It is not. There is no one can influence the judiciary. Right? So first one is security of tenure. Security of tenure. What do you mean by security of tenure? I told 65 years is the age of the retirement, and there is a procedure in the Constitution to remove the judges of the Supreme Court. The Constitution has provided a procedure. It has provided security of tenure. You cannot remove a judge of the Supreme Court easily. There is a big procedure. That is why till now no judge of the Supreme Court has been removed, impeached. Why? He is provided with security of tenure. If it is very easy to remove a judge of Supreme Court, then if a judge of Supreme Court gives any adverse judgment against any government authorities, then easily he could have been removed, no? Then there won't be any independence, right? It would have been biased, by now corrupted, right? To avoid that, our framers of our Constitution has provided security of tenure. Once the judge of Supreme Court appointed, it will be very difficult to remove him from the position, right? It is very difficult to remove him from the position. See, that is why, have you heard about electoral bonds? Electoral bonds case, right?
Companies.
Yeah, they could purchase the electoral bonds and fund the political parties. There was a provision. So, Supreme Court, I think, I forgot the case name. This is electoral bonds case. Just check the case name. Just write it down, man. It is actually important for your exam because it was in current affairs. Electoral bond case. Okay. Electoral.
Ask the commission to show the whole investigation.
No, that was as a part of the inquiry. Later on, as a hearing. Later on, Supreme Court said that electoral bonds itself is unconstitutional. Got right? Electoral bonds itself is unconstitutional. It squashed it. Right? So just check what is the case name. Name of the case. Electoral bonds. I forgot. I think Janhit Abhiyan or something is there. I think Janhit Abhiyan or something. Just check the case name. It is popularly called as electoral bonds case. Okay. There will be a person. No. Janhit Abhiyan was a state of Government of India or State of India case, right? Just check what is the name. Okay. So in the electoral bonds case, it was started by Government of India, right? So the Supreme Court itself told it is unconstitutional, squashed it. If there is no security of tenure, you think it is very easy for judges to give judgments against government? It might not be. It may not be, or may not, it may be or may not be, right? But because the Constitution has provided security of tenure, it is giving independence. The Supreme Court is taking decisions independently, right? That is one such case where it went against. There is something called, another one is NJAC, National Judicial Appointment Commission. National Judicial Appointment Commission case, where the Government of India in the first term of in 2014 or 15 I guess, they passed National Judicial Appointment Commission Act to appoint the judges of the High Court and lower courts, right? That was squashed by Supreme Court, saying that appointing the judges by the collegium and president, that is a part of basic structure, right? That is also done by Supreme Court. So there is a independence. Security of tenure is there, that provides independence. Clear? Fine. Second one, mode of appointment. Mode of appointment. What do you mean by this? Mode of appointment? What is the meaning? The judges are appointed by who? President on recommendation of who? Collegium. They are part of judiciary itself, no? Getting my point, right? The judges of the Supreme Court are appointed by a collegium consisting of judges of Supreme Court itself. Even though the president appoints the judges of Supreme Court, it doesn't mean that the president do it on advice of cabinet. Correct? No. The president, in all other appointments, the president do it on advice of cabinet. But here the president do it on the advice of collegium. That is nothing but part of judiciary. Who are part of collegium? It consists of collegium plus 4 senior most judges. They are part of Supreme Court. The judges of the Supreme Court will appoint judges to High Court as well as Supreme Court. Alright? So executive body does not have any control over appointments. So mode of appointment is by the judges only. So there is no interference. Right? It provides independence. Correct? Understood with this one? Mode of appointment, the judges of the Supreme Court and High Court are appointed by judges themselves. Even though they are appointed by president, the recommendation is done by collegium only. Correct? Okay? Clear? Next, fixed service conditions. I explained this already. Fixed service conditions. Fixed service conditions means their salary allowances cannot be changed to their disadvantage, right? If you want to write, like, the salary allowances are determined by from time to time by parliament, right? It cannot be changed to their disadvantage after their appointment. It cannot be changed to their disadvantage after their appointment except during financial emergency. The salaries and allowances cannot be changed to their disadvantage. What do you mean by disadvantage? It cannot be reduced. The salary allowances can be increased by parliament. It cannot be reduced. It can be reduced only during financial emergency. Except during financial emergency, their salary and allowances of the judges cannot be reduced. Right? It cannot be reduced. Okay? It cannot be altered to their disadvantage. You can say it cannot be reduced. Except during financial emergency. Except during financial emergency, the salary and allowances of the judges of the Supreme Court cannot be reduced. Okay. Next one, this one you know, the expenses are charged on the Consolidated Fund of India. So which is not subject to vote of the Parliament. All the expenses of the Supreme Court are charged upon the Consolidated Fund of India, which is not subject to vote of the Parliament. Right? Parliament can only discuss it, cannot vote. Okay. Rest of the things don't write it. Just I will tell you. Just hear it out. It is not very much needed. The conduct of the judges cannot be discussed. Correct? Means you cannot say in sitting in a newspaper, sitting in a TV channel or newspaper saying that the judge is bad, he's giving false judgments. You cannot do it. It amounts to contempt of court. If you do it, then court can, punish you, right? It cannot be discussed. Conduct of judges cannot be discussed, right? Then that is what contempt. Then this one you write it. The jurisdiction of the Supreme Court cannot be curtailed. The jurisdiction of the Supreme Court cannot be curtailed by the Parliament. It can be extended, but it cannot be curtailed. The jurisdiction of the Parliament cannot be curtailed. Means it cannot be reduced. You cannot say that currently Supreme Court has jurisdiction over something. Tomorrow the Parliament cannot say that the Supreme Court does not have jurisdiction over that. It can be extended, but it cannot be curtailed. The jurisdiction of the Supreme Court cannot be curtailed. Okay, so we'll take a break. 10 minutes will start. Just mute it, no?
Actually, she and her brother were going to Phoenix and the bike was used.
She is in a hospital or home?
Nobody in hospital, so they just came to home. And every day they were for dressing.
Small things.
Yeah, Pooja a bit major mistake, but his brother, and her brother.
Major means what?
Like too many places for princess.
Only had not fracture.
No, not fracture.
But is not major. Okay.
Yeah. So next, jurisdiction and powers of Supreme Court. Jurisdiction, or you can write powers of Supreme Court. Jurisdiction and powers of Supreme Court. Okay. First one is original jurisdiction. Original jurisdiction. Okay. Original jurisdiction. What do you mean by original jurisdiction? What do you mean by original jurisdiction? See, have you heard, right? You have heard, right? If there is a case in Supreme Court, first you will appeal to local court, right? If you are not satisfied with the judgment, you will go to session court. If you are not satisfied with that, you will go to High Court. If you are not satisfied with High Court, you will go to Supreme Court. That is called appellate jurisdiction. Appellate, by means of appeal. Appellate. Then there is something called original jurisdiction. What does it mean? You can directly approach the Supreme Court. You need not to go to Supreme Court by means of appeal. Your issues, you can directly take it to the Supreme Court, where if the dispute is between two states, if the dispute is between state and center, you're getting my point, right? If the dispute is between center or one or more states, or if the dispute is between states, then the issue can be taken to Supreme Court. Correct? No. If there is an issue between Karnataka and Tamil Nadu, that cannot be handled by Karnataka High Court, because Karnataka High Court has jurisdiction over only state of Karnataka. High Court of Tamil Nadu has jurisdiction only for the state of Tamil Nadu. Who will decide the issues? Then it is the Supreme Court. So that is the original jurisdiction, where you can directly go to Supreme Court with your issue. You need not to go by means of appeal. That is called original jurisdiction, where if the dispute is between center and one or more states. Recently, Karnataka government, when there was related to tax, not actual tax devolution, that one it was not challenged, related to flood relief. Tax devolution, they did protest in Delhi. Flood relief, it was not released. At that time, they filed a case in Supreme Court. And later on, before it was resolved, central government released it. So that case was withdrawn, but that was filed. You got my point, right? If there is an issue between center and state, that can be filed in Supreme Court. That is the original jurisdiction. If the dispute is between two states, related to, currently Karnataka is having a border dispute with which state? Maharashtra, over Belagavi and other regions. Right? With Maharashtra, we have a border dispute. Right? So there is something called Mahajan Commission. That you don't need it. So, with respect to border dispute with Belagavi, the case is filed in Supreme Court because it is an issue between Karnataka and who? Maharashtra. And there was an issue related to water dispute, related to Kaveri water. That case was also if there is no proper monsoon, then there will be shortage of water in Kaveri basin. Then there will be clash between Karnataka and Tamil Nadu. Tamil Nadu will say that Karnataka is releasing enough water, and they will go to Supreme Court. Alright, Supreme Court will say you have to release many waters, and those many kind of judgments will come. So, but the dispute will be directly taken to the Supreme Court. No other court can handle it. So that is called original jurisdiction. Understood? Even in one more case, the original jurisdiction is there. Which one is that? Under Article 32. We will study under jurisdiction, but that is also original, right? Yeah, if your fundamental rights are violated, huh?
Rights of fundamental.
Yeah, fundamental rights, if your fundamental rights are violated, you can file a writ directly in Supreme Court. You need not to go by means of appeal. You have an option, but it is not exclusive. You can go to either High Court or Supreme Court, but you can directly approach Supreme Court as well. Correct? No? Right? Fine. Next one is writ jurisdiction. Writ jurisdiction, that is what we discussed already. Just write the heading. Writ jurisdiction. What are the types of writs we have?
ABS process, mandamus,
Certiorari, quo warranto, and prohibition. Right? For writ jurisdiction, if we under which article? Writ jurisdiction? 32. High Court.
High Court, 100.
Writ jurisdiction, which article? Should not forget these things. Huh? No. 226. 226. Writ jurisdiction of High Court. Right? Jurisdiction. Supreme Court can issue writs for the violation of fundamental rights under Article 32. Right? Next one is appellate jurisdiction. Appellate jurisdiction. Appellate jurisdiction. This you know, right? Just now I told you. Huh? Appeals. Appeal against judgment of the High Courts. There is no other provision. That is the apex. That is why it is called as apex court. They can file a review petition. If you see last year UPSC question, I guess last year 22 or something. It is just a review petition. They can. You can once you are done with your judgment. If you are not satisfied with the judgment, you can file a review petition. Then the judge will not hear it in open court. You can write all your objections and you have to hand it over to him. The thing will happen in this chamber. They can accept it or reject it. But most of the case, the review petitions will not be entertained because the judgment is given by Supreme Court. So that is done actually. The Supreme Court is given a judgment. Only if it is related to criminal cases, you can approach for pardoning power. Pardon from the President or Article 32. No other options. You have to, that is the apex court. Otherwise, then there are no other court. No, Supreme Court is also saying means that is done. Right? So that is appellate jurisdiction. Alright? Fine. Next one is there is something called advisory jurisdiction. This one you must know. Advisory jurisdiction. Advisory. Sorry? Separate. Advisory jurisdiction. Under Article 143. Don't forget this article, important. Advisory jurisdiction under Article 143. Okay. Here, I'll dictate it. Just first try to understand. Under Article 143, where the President can seek the advice of the Supreme Court. Under advisory jurisdiction, the Supreme Court can give advice to the President on some matters where advice is asked by the President. Okay, there are two things. One is related to a non-order matter that has issues. President can ask it. Second one, if the matter is related to any treaty, pre-constitutional treaty, or related to any international agreements, there also President can ask it. In first case, if it is related to law and order issues or any law-related issues, the Supreme Court can refuse to give advice. Whereas if it is related to pre-constitutional treaties, the Supreme Court cannot refuse to give advice. Court must give its advice. But the advice tendered by Supreme Court is not binding on the President. It is not binding. Okay? What is advisory jurisdiction? Where the Supreme Court can give advice on the matters which are referred to it by President. Two cases. Okay? Supreme Court, first case is any question of law or fact of public importance. Any question of law or fact of public importance Any question of law or fact of public importance which has arisen or which is likely to arise. Any question of law or fact of public importance. Any question of law or fact of public importance which has arisen or which is likely to arise. Okay? Which has arisen or which is likely to arise. That is under Article 143, this is option A. Second one, B, is dispute arising out of any pre-constitutional treaty or agreements. Dispute arise out of any constitution, any pre-constitution treaty or agreement, etc. Pre-constitutional treaty or agreement, etc. Okay. So here in option A, I mean in first thing, in first point what I told now, there the Supreme Court may refuse to give advice. But in second, that is if it is related to pre-constitutional treaty or agreement, the Supreme Court must give its opinion. Okay, must give its advice. In first one, the Supreme Court may refuse to tender advice, but in second, the Supreme Court must give its advice. Right? But it is only advice. What is it? What do you mean by that? It is not binding on the President. The advice tendered by the Supreme Court is not binding on the President. It doesn't mean it means that the President need not to consider it. It is just advice. Okay, he can seek the opinion of the Supreme Court. Clear? That is advisory jurisdiction. Then there is something called court of record. Court of record. Court of record. Court of record means the judgment of the Supreme Court are used as references for the judgments of the high courts, right? Judgments of the high court, and at the same time, Supreme Court has the power to correct its own judgments. As a court of record, it has the power to correct its own judgments. Getting my point, right? If Supreme Court has given judgment today, then consequently, in some other cases, the Supreme Court correct its own judgments. Right? Related to Constitution, we hear about Keshwananda Bharti case, Minerva Mill case, right? These are all the corrections done by Supreme Court from time to time.
Then the person will not get a justice.
It is not related, yeah, that is what. At that time, the interpretation of the judge is like that. It is not related to criminal matters. It is related to constitutional matters. Getting my point, right? In first case, in Supreme Court, in first judge's case, second judge's case, third judge's case. In first judge's case, Supreme Court told that the opinion, it is only consultation. Right? Till second judge's case, that was followed. In second judge's case, it told it is not consultation, it is concurrence. Third judge's case, it told it is not just the concurrence, it is opinion of the CJ plus 4 senior most judges. Getting my point, right? So it can correct its own judgments.
On
Constitutional matters. Not criminal matters, there is no point only. See, criminal matters, it is related to individual person. If you do a mistake, you have got a punishment. If I do a mistake, I will get punishment. My case is not related to yours case, right? They are different things. But when it comes to constitutional matters, the interpretation varies.
But when the crime is
Crime means it is purely based on the evidences. You are getting my point, right? There is nothing called interpretation. But in constitutional matters, it is always about interpretation. Our constitution says right to life and personal liberty. Right? No, that is a fundamental right. Our Supreme Court interpreted that in different ways. I told you one case, Ranjit Singh case, where Supreme Court told right to life also includes right against adverse impact of the climate change. That is an interpretation. That is from time to time, based on the changes that happens in the society, the court will give a different interpretation as a court of record. Got my point, right? Clear? Fine. So, next is power of judicial review. Power of judicial review. Power of judicial review. Which article deals with power of judicial review of Supreme Court? Should not given 2 days holidays for now. No? Yeah? Which article deals with judicial review?
145.
Or randomly you are saying some other.
147 it was.
you should be confident enough to say that. No, you are only doubtful about it. It is 13. 13 deals with judicial review, right? Article 13 deals with judicial review. Means the Supreme Court can review the. Huh? What do you mean by judicial review? The act of Parliament or state legislature, whether it is infringing with the fundamental rights or violating the Constitution. It's called as ultra virus. I told na, ultra virus. Whether it is violating the Constitution or not. The Supreme Court will review the acts or any bills passed by the state legislature as well as Parliament to check the constitutionality. That is called as ultra virus. I spoke about the NJAC, no? NJAC, National Judicial Appointment Commission Act. Parliament passed the act. Even Supreme President gave assent, but it went for judicial review. The judicial review means the Supreme Court. It was challenged in the Supreme Court. Supreme Court reviewed it and said it is unconstitutional and squashed it under Article 13. You're getting my point, right? It called it as unconstitutional. And there is one more thing, Aadhaar bill. I was talking about Aadhaar bill, no? So it was also challenged in the Supreme Court. Supreme Court said it is correct, it is constitutionally right. Next one is 105 Constitutional Amendment Act related to what? 105. EWS is what? 102. 102 or 103? 103, right? 102 is related to OBCs. Right? Constitutional status to National Commission for Backward Classes. Right? NCBC. So 103 is related to EWS reservation, where 10% reservation was given to anyone from general merit. You right? You have taken EWS certificate? Yeah. What do you father doing? I mean,
It's a contractor, sir.
we have income limit or proper no, because one of my friend had taken and he got selected, he was squashed. He was rejected by UPSC. Be careful with that.
What is the what?
Income limit. They had taken the EWS certificate by doing something, but later on when the income was checked, no, it breached. That limit was crossed. So be careful with that. PAN card is there, no, tax. He pays tax, no,
Yes, I did.
but definitely it will be more than 8 lakhs then.
Yes, sir.
Be careful with that. Simply don't, because EWS nowadays they are very much particular about it. You heard about a person called Shantappa. He was a sub-inspector. Last year he cleared UPSC. Kuruvar. He got IPS actually, but he was rejected by UPSC. That you don't know. You won't tell that in YouTube channel. He was rejected by UPSC. I think he resigned from PSA as well. I know him. I think he resigned. He's not working now. That is why he's doing YouTube channel classes and all. Again, income issues. OBC certificate was rejected.
He is not able to any positions in the civil.
He is rejected from the list itself. He cleared in OBC, no?
Yes.
You are not eligible for OBC, man. Then you are out. Done. So be careful, because if you don't clear prelims now, that's okay. I mean, that is not okay, but you clear prelims, mains, interview, you will be in list. But then, because of your income certificate, if they reject you now, it is like a heartbreak. So while applying for reservation, be careful with that. Okay? Check it and apply. Simply, those guys know they will nowadays, because there are various issues that people are challenging, that especially that Shantappa case, right? So NJAC, National. So why did this thing come up? EWS reservation. Yeah, EWS reservation is 103rd Constitutional Amendment Act that was passed in both houses of the Parliament, right? So what it deals with, giving 10% reservation for those who were not covered under any of the reservations. So that was challenged in Supreme Court because in Indira Sahni case in 1992, it is popularly known as Mandal case. Right, I told you, Mandal case, where Supreme Court told that it put a cap on reservation. Indira Sahni case, where it said that the total reservation shall not be more than 50% of the seats. It put a cap, except under extraordinary conditions, the reservation shall not breach 50% limit. Right? But here 10% more means it is 60%. So that was challenged, where Supreme Court told that it upheld the constitutional validity of EWS reservation. So that is judicial review. You got it right? What is judicial review? Where it was challenged. Supreme Court checked the constitutional validity of that particular act and upheld it. So it became constitutionally valid. Right? So that is judicial review. Right? There are various cases of that sort, like judicial review, for judicial review only. Okay? Fine. Okay? No doubt? Yeah. So, that is about Supreme Court. Okay? So, what are the things you must remember here? What is the qualification of judges? Right? Okay. What is the qualification of judges? Yeah. Make it very simple one. 5 years judge of High Court or Consecutive High Courts, then 10 years advocate of High Courts or Consecutive High Courts, then distinguished jurist. What is the minimum age? No minimum age. Alright. Next, third one. Resignation. Good. Resignation to President. What is the procedure for removal of a judge of Supreme Court? Then oath. Oath? President. Right? Next. One more thing. What is one more thing? Retirement age. What is the retirement age? 65 years. Then appointment by collegium consisting of plus 4 senior most judges. Which judges case? Third judges case Supreme Court told it is not just the opinion of the CJ, it is the opinion of the CJ plus 4 senior most judges. Even if 2 judges give adverse opinion, he should not refer those names to the president. Right? Then removal. How many members has to sign the resolution to? In case of Lok Sabha, 50 members in case of Rajya Sabha. Yeah, it can be introduced in, if it is in Rajya Sabha, 50 members has to sign. If it is in Lok Sabha, 100 members has to sign. Right? Once it is signed, the speaker can accept it or reject it. If accepted, he needs to form a committee consisting of who? CJ or senior judge of the Supreme Court, 1. Second member, Chief Justice of High Court or CJ of High Court. Third one, a distinguished jurist. The committee will conduct inquiry and submit report to this presiding officer. Then the resolution will be passed. We need to be passed in the House with what majority? Special majority. Is there any concept of joint sitting? Joint sitting is allowed? No. Both the houses have to pass the resolution with separate special majority separately. If the one house rejects it, then that is done. Right. Then the resolution will be sent to President and judges will be removed by President. Okay. Next. What else? Charged on the Consolidated Fund of India. Means it is not subject to vote of the Parliament. Right? Fine. Next. Independence of Supreme Court. So first one is security of tenure. Means they can be removed only through the procedure mentioned in the provided in the Constitution. Second one, mode of appointment. The judges are appointed by the judiciary itself. Right? Executives have no control over the appointment of judges. Third one, service conditions. Means their salary allowances cannot be changed to their disadvantage. Right? After their appointment. Okay? It can be increased, that will be done by Parliament. The increase also, salary will also be done by Parliament. That can be increased but cannot be reduced. To their disadvantage, no changes can be made. No changes can be made. So next one. Conduct of judges cannot be discussed by anyone. Right? Fine. It amounts to contempt of court. Right? So next one, this one, what is that? Powers of Supreme Court. Jurisdictions. Powers of jurisdiction of Supreme Court. Original jurisdiction. What does it mean? Where the cases can be heard directly, without by means of appeal. Without by means of appeal. So if the dispute is between the center and state, or between the states, it can be heard directly by the Supreme Court. Second one, writ jurisdiction. Under which article? 32? No, here in High Court we mention High Court 226. Here it is only Supreme Court under Article 32 can hear writs. Right? What are the types of writs we have? Habeas corpus, mandamus, certiorari, quo warranto. Right? Then writs are like what is next thing? Appellate jurisdiction means the case can be taken to Supreme Court by means of appeal against the judgment of the High Court. It is always High Court. After High Court, you can't bypass the High Court and go to Supreme Court. If you go there, Supreme Court will send back you to High Court again by means of appeal. Right? Next is advisory jurisdiction. Which article deals with advisory jurisdiction? 143. 143. Never forget this, okay? 143. Where under two circumstances the President can seek the advice of the who? Supreme Court. First circumstance is any law and order public importance issues. Right. Second thing is pre-constitutional treaty. Any issue arising out of pre-constitutional treaty or agreement. In first case, the Supreme Court must. Second case, good. In first case, the Supreme Court can refuse to give advice. But if it is related to pre-constitutional treaty or agreement, then that is second case where Supreme Court must give its advice. And the advice tendered by Supreme Court is not binding on the President. It is not binding on the President. Means President need not to consider them. It is just advice. Clear? Oh. That's all, no? Clear? Fine. Huh?
After the retirement, they cannot pass the
Yeah, I will tell you that. Yeah. After the retirement, the judges of the Supreme Court, they cannot practice before any court as advocates. Okay? They cannot practice. Why? That is again independence of Supreme Court. Right? They cannot practice. Clear? Ban on practice after retirement. They cannot practice. Why? Because if you allow them to practice, no, what happens? I mean, it is not like it will happen. It is a protection. If you allow a Supreme Court judge to practice means to function as an advocate, right? That is not practicing. So he is an advocate of Supreme Court judge. Earlier he was an advocate, right? If you allow him to practice, there are chances that it's just anticipation. He can give a judgment in favor of a company and person, and later after retirement he can become his advocate, and he can take money. So it might affect the judicial process, right? So for that, this provision is provided. They cannot practice after retirement. Okay. So if a judge of Supreme Court after 65 years, he cannot practice before any court of law in India.
There is no specific age mentioned for advocates.
Means
Advocates retirement.
no, he can become advocate for till he, there is someone called Fali Narayan. He was advocate of Karnataka for Kaveri issues. Till he passed away, he was advocate for Kaveri issues. But for advocates, the more senior he is, Kapil Sibal is not that old, I guess. He's on 65, 70, 75 years. Right? The more old he becomes, more fees he can charge. Kapil Sibal and all, they are one of the costliest lawyers of India. Advocates of India. Fine. So next is state government. Okay? State government. We will do emergency. We will finish emergency. We will finish emergency and we will go to state government. Because 1 hour, if I start state government, maybe half completed. Emergency, I won't take half 1 hour, but we will do it. How much? Then we will start state government. Okay? Fine. Part 18 of the Constitution deals with emergency provisions. Part 18 of Constitution deals with emergency provisions. Article 352 to 360. Article 352 to 360 deals with emergency provisions. Okay. Why these provisions are provided in the Constitution? To meet any abnormal situations or emergency situations. To meet any abnormal and emergency situation. During emergencies, the federal structure of our polity becomes unitary. Right? It becomes unitary. So that is called emergency provisions. There are three types of emergencies. Huh? Provision means, what do you say, man? Provision. It is a, what do you say that? Word, alternative word. What do you mean by provision? I mean, any alternative word for it is a, what do you say that? Emergency provisions means it is provided in the Constitution. It's a method provided in the Constitution, not exactly method. Alternative word. Any alternative word for provisions? So it is a problem. No. Meaning means, I mean, I know I'm not getting how to explain it. Rule. Huh? Not rule. I'll check the exact word and I'll tell you. It is not exactly power. Power is also not correct actually. It is a provision means. Okay, fine. Emergency provisions are provided under 352 to 360. There are three types of emergencies. What are the three types of emergencies? National emergency, president rule, or it is also called as constitutional emergency. Third one, financial emergency. Okay, we have three types of emergencies.
Supplying is another one.
Huh?
Supplying.
No, that is in another context. Provision store, you are saying in that concept it will come, but here it is not that. Yeah, kind of. It is a provision means it is a provision. Kind of. It is a requirement, condition, a that actually. Sometimes it will be there. That word will not strike to your mind. Okay, I'll tell you. No. So there are three types of emergencies, right? What are those three? First one is national emergency. Deals with Article 352, President rule, or constitutional emergency under Article 356, financial emergency 360. Okay, we have three types of emergencies. So first one is national emergency. Article 352. Okay. National emergency. Who can declare national emergency? I mean all three emergencies. It is the President can declare all three emergencies. It is the President who can declare. Is it raining or something? Yeah. So, President can declare national emergency. So, what are the conditions for declaring national emergency? If the security of the India or any part of India is threatened, that is war or external aggression, there are two conditions to declare national emergency. First one is war or external aggression. Second one, armed rebellion. Armed rebellion. So earlier there was another condition, war or external aggression. Second one, armed rebellion. Okay. Earlier there was another condition called internal disturbance. In 1975 it was 1974, emergency was declared based on internal disturbance. So that provision was replaced with armed rebellion by 44th Constitutional Amendment Act. Okay, this provision armed rebellion is there, no? It is added by 44th Constitutional Amendment Act. Originally there was a provision called internal disturbance. It was vague, right? What exactly internal disturbance means is not mentioned, so it left to so much of foul play. So they added a new provision called, they removed internal disturbance and added a provision called armed rebellion. Okay. Now national emergency can be imposed for war or external aggression, armed rebellion. It doesn't mean that there has to be war. If there is a threat also, national emergency can be imposed. Before the actual war also, the national emergency can be imposed. Okay. So what is the procedure? Okay. Internal disturbance is removed by 44th Constitutional Amendment Act of 1978. Right? Fine. Next one is, what is the procedure? It doesn't mean that president can declare on his own. Right? He can declare national emergency on the advice of the cabinet headed by the Prime Minister. It is not just the sole opinion of the Prime Minister, it is the advice of the cabinet headed by the Prime Minister. They need to advise it to the Prime Minister. Okay. After the advice of the cabinet, he can declare a national emergency. First you understand, then you can, I'll dictate it to write it. Okay. First you understand the procedure. So once President, the cabinet recommended for national emergency, it is imposed. Right? It will be in force for how many months? 6 months. After 6 months, it will automatically cancel. It will be revoked automatically. Okay? Then it will be forced for 6 months. Once the national emergency is invoked by President, then the resolution has to be approved by both the houses of the parliament, that is Lok Sabha and Rajya Sabha, separately with special majority within 1 month. Got my point, right? Once the national emergency is invoked by President, then both the houses of the parliament, that is Lok Sabha and Rajya Sabha, must pass the resolution of approving the national emergency within 1 month with special majority. Earlier it was 2 months with simple majority, but 44th Constitutional Amendment Act of 1978 made it within 1 month with special majority. Earlier it was only simple majority. 44th Amendment Act made it special majority. Okay. So the national emergency can be imposed by President on the advice of Council of Ministers, cabinet headed by Prime Minister. Then once it is invoked, then it will continue for 6 months, and after the invocation, after the national emergency is imposed by President, then it has to be approved by both the houses of the parliament with the special majority within 1 month. Both the houses of the parliament must approve the imposition of national emergency with special majority. That this provision is added by 44th Constitutional Amendment Act of 1978. Originally it was simple majority within 2 months, but 44th Amendment Act 1978 made it 1 month with special majority. Both the houses separately must approve the national emergency with special majority within 1 month. With the special majority within 1 month. Understood? Clear? Fine. Okay. If it is approved, it will continue for how many months? 6 months. It will continue for once it is imposed by president, it will continue for 6 months. Next, revocation of national emergency. Revocation of national emergency. The president can revoke national emergency on the advice of the cabinet. Okay. The president can revoke national emergency on advice of the cabinet. On the advice of the cabinet, the president can revoke national emergency, and there is no parliamentary approval is needed. Parliamentary approval is not needed for revocation of national emergency. Parliamentary approval is not needed. Parliamentary approval is not needed. But if the Lok Sabha passes a resolution, okay, if Lok Sabha passes a resolution with a simple majority that the emergency has to be revoked, then president must revoke the national emergency. Got it? No? If Lok Sabha passes a resolution with simple majority for revoking national emergency, then president must revoke national emergency. Okay. Lok Sabha, simple majority, then president must revoke. If Lok Sabha passes a resolution for revocation of national emergency with simple majority, then president must revoke national emergency. Okay. Then president must revoke national emergency. So while revoking national emergency, Rajya Sabha has no role. I told you now while doing Rajya Sabha, unequal status. I told you right, while doing unequal status, it is only Lok Sabha can pass a resolution for revoking national emergency. Rajya Sabha has no role in it. Got it right? So while imposition of national emergency, both the houses of the parliament, that is Lok Sabha and Rajya Sabha, must pass the resolution with what majority?
Simple. When sir?
Imposition.
Imposition that is special.
Special majority. Separately. Originally it was simple majority, but 44th Amendment Act made it special majority. Within how many months?
Within
1 month. Originally it was 2 months. 44th Amendment Act made it 1 month. Right? Next, while revoking a national emergency, only Lok Sabha, if to revoke a national emergency, president can revoke it on the advice of the cabinet, and for that parliamentary approval is not needed. President can just issue an order and revoke the national emergency. But if parliament passes a resolution, with simple majority, then president must revoke national emergency. There is no option left for president. He must revoke the national emergency. Yeah. If Lok Sabha passes a resolution with what majority? What majority? If Lok Sabha passes a resolution with simple majority, then president must revoke the national emergency. You got the difference, right? While imposition, both the houses will come into picture. Both Lok Sabha and Rajya Sabha, both must pass the resolution with special majority. While revoking, parliamentary approval is not needed. But if Lok Sabha passes a resolution with simple majority, then president must revoke the national emergency. Yeah. Then let him come now. You can do that. Huh?
Yes, sir.
You want to write test? Huh?
Only 10 minutes.
Okay. I'll leave at 4:50. 4:50. We'll train, man. We should go. I should try 30 kilometers.
From where you are coming?
From Panchangi, Kathari.
From Banishan you are coming.
Yeah. We'll continue. One person is not there means 33% absent. There is one more girl. Okay, that she met with an accident. When exactly your exam? September?
Not yet.
Tentative is not. Tentatively,
What about SSA exams? When do we have? We didn't get the notification.
there is some controversy going on regarding this.
Yes, sir, but when we were applying, we got to know that is on August 12, something like that.
Yeah.
We were checking our mails, but we haven't got any
Mails,
notification.
SSC gives before 3 days, sir.
But timetable they will give. What exact schedule?
No, our admin card
Yeah,
is 3 days.
that is before 3 days. Yeah. There is some controversy going on regarding
Yes, sir.
repeated questions or something.
So the computer was shut down due to the
Yeah.
examination.
This is type 1, right? Type
Yes, sir,
1 now.
type 1. Just before 3 days they required admit card.
Yeah, I think so. I haven't written SSC. Once I had applied, but I didn't write it. I don't know exactly. But this is the first time because I'm writing.
Yes, sir.
You are also writing.
We actually tried our best to take questions for SSC, sir.
Hmm.
The thing is like, we didn't get mathematics right.
Aptitude.
It's aptitude is one of the biggest problem for us.
Read R.S. Agarwal.
Sorry, sir.
R.S. Agarwal.
What is that, sir?
Textbook.
Reading is different, explaining is different.
No, the textbook is actually nice.
R.S. Agarwal.
Agarwal. That is the Bible for all your aptitude kind of questions. R.S. Agarwal. The textbook will come. They are given for, I mean, for every aptitude usually, even if it is for UPSC or whatever state exams, now, everyone will refer R.S. Agarwal, even for the campus placements, for everything.
But we are just basics, no, so like how the problem.
You go through, you just download the, if you get online for free, just download it and you see once. You'll understand it. You don't have like, there's no need of any teaching. You can easily get that. And for shortcuts, go for some videos. Especially for, permutations and combinations, all those things. There are many YouTube videos that explain it easily. Go through it. Start man actually. Yeah. So, effects on life of Lok Sabha and state legislature. Effects on life of Lok Sabha first and state legislature. Effects on life of Lok Sabha and state legislature during national emergency. We are talking about national emergency. Effects on life of Lok Sabha and state legislature. Effects on life of Lok Sabha and state legislature. Okay. The life of Lok Sabha can be extended, and as well as state legislature can be extended 1 year at a time. During national emergency I am talking about. The life of Lok Sabha and state legislature can be extended 1 year at a time for any length of time. The life of Lok Sabha and state legislature can be extended 1 year at a time. The life of Lok Sabha and state legislature can be extended 1 year at a time. 1 year at a time for any length of time. What does it mean? For any length of time. Means, see, currently there is a 5th year of Lok Sabha is in running. Okay, the elections are supposed to happen in some month. Say we are in August, no? August, yeah. September there is supposed to be elections to the Lok Sabha. But in August, the national emergency was imposed in the country. So our constitution authorizes the election can be conducted. There is no bar on that. It is not like during national emergency the elections cannot be conducted. There is no such limitations. But constitution provides a provision that during provision we can say it is an avakasha. We can use that word. Emergency avakasha is constitutional. ಆ ಥರ ಹೇಳ್ಬೋದು ಎಕ್ಸಾಕ್ಟಾಗಿ ಬೇರೆ ವರ್ಡ್ ನೋಡುವ ಬಟ್ ಆಯಿತಾ ಬಟ್ ಅವಕಾಶ ಆ್ಯಕ್ಚುಲಿ ಆಪರ್ಚುನಿಟಿ ಅಂತ ಆಗುತ್ತೆ ಬಟ್ ಇದು ಆಲ್ಸೋ ಯೂಸ್ ಮಾಡ್ಬೋದು ಏನು ಹೇಳ್ತಿದ್ದೆ ಯಾ Say August national emergency was imposed. Okay. By September the elections supposed to happen in say national parliament elections, Lok Sabha elections. So then the length of the parliament can be extended. Current elections were supposed to happen in September. It can be extended till 2027 September. It can be extended 1 year because when national emergency is in force at a time for any length of time means till next September it can be extended once. Once next September comes, then there is national emergency is there in force still. Then it can be extended for another year. Then again for another year. Like that, it can be extended till any length of time, but 1 year at a time. Got it? No? It can be extended from this September to that next year September once. Next year September again a resolution has to pass in parliament. Then that can be extended for another length of time, for another 1 year. Again, after 1 year, one more resolution, 1 more year. Like that, it can be extended for any length of time, but 1 year at a time. At once only, you cannot extend it for 3 years, 4 years like that.
Here, the president has power to announce the emergency. She should require whether it is 6 months the president power. Then how it is 1 year.
I'll come to that. National emergency can be imposed for 6 months. That can also be extended for every 6 months. It can extend for any length of time.
Then this will be imposed by who? Parliament.
Parliament will extend it.
Parliament only.
Yeah, Parliament will have to pass a resolution. Then President will impose it. It is the Parliament must pass a resolution that extending the term of the Lok Sabha. Rajya Sabha, that question will not arise because Rajya Sabha is a permanent house. Only in Lok Sabha the resolution has to be passed. Only Lok Sabha's life has to be extended because the election must be conducted. Similarly, if all the state assemblies will not be at the end of 5th year, right? Only few will be there. Suppose if Karnataka, if it is the term of the Karnataka Legislative Assembly is ending, then that can be extended for a period of 1 year. But it cannot go beyond 6 months after the emergency has ceased to operate. I'll explain what exactly it is. Just write it down. But the extension cannot continue beyond 6 months after the emergency has ceased to operate. Okay. This extension cannot go beyond 6 months. This extension cannot go beyond 6 months after the emergency has ceased to exist. After the emergency has ceased to exist. Okay. What does it mean? See, we'll take an example. Okay. See, we are in August, right? August, emergency was imposed for 6 months. August to September, October, November, December, January, February. Correct? No? Till February it was approved by Parliament. Right? Approved by Parliament. Say in November, elections to Parliament was supposed to happen. So the life of Lok Sabha was extended for how many time? For how many months? 1 year. Right? Till next November. So they extended the life of Lok Sabha for 1 year. But in February, the emergency was supposed to end. If they want to extend, they have to pass a resolution again and they need to extend it for another 6 months. But they decided to lift the emergency. So February emergency was ended. Then what our constitution says, this extension cannot go beyond 6 months after the emergency has ceased to exist. Got the difference, no? This extension of the house cannot go beyond 6 months after the emergency has ceased to operate. Means February to March, April, May, June, July, August. For August it is 6 months. February to August is 6 months. Till August the house can be extended. Before that the election has to be conducted. Because February only emergency has ceased to operate. Our constitution says this extension go only 6 months after the emergency has ceased to operate. Only 6 months. Emergency has already ended in February. From here to 6 months, the emergency life of the Lok Sabha or state legislature can be extended. So it can go up to only August. Before August, the election must be conducted. Got it? No? Got it, or you want me to explain it again? Once the emergency is ended, the extension of the house can go 6 months after the emergency. That's all. Even though 1 year is extended, it can exist. If the emergency is continued from February to another 6 months, then it can go beyond that. Correct? No. But emergency ended in February only. So from here to 6 months it can go. I mean the house can be extended. Before that the election must be conducted to the house. Clear? Understood? The extension can to continue beyond 6 months after the emergency has ceased to operate. It can continue only for 6 months after the emergency has ceased to exist or ceased to operate. Clear? Understood, right? How are you going to explain again? You?
Sir, what is this, sir? Lok Sabha and state can be extended for 1 year at a time for any length of time.
Yeah. That is what I told you.
That's what.
Now emergency is in operation, right? You cannot extend the state or legislative assembly. When the question of extending the term comes, if the term is ending, if the elections are conducted last year and emergency is imposed this year, then there is no point of extending now, because you have your 5 years full term. Suppose the term is ending. Getting my point, right? Say this year election happened, 2025. 2030, there is supposed to be election to parliament, that is Lok Sabha, right? In 2030 beginning only, you imposed national emergency in the country, right? But 2030, say August, you are supposed to go to elections. But before that only national emergency imposed. If you want, you can go to elections. Suppose if national emergency is imposed on what grounds? If there is war or external aggression or armed rebellion. If there is war or external aggression, there has to be a government. The government cannot come and conduct the elections. They need to focus on national security. At that time, what they will do? The provision is provided in such circumstances. Other than going for elections, you can extend the term of the Lok Sabha from 5 to 6 years. 1 more year. Your term was 5 years. You extend it for 1 more year, so that MPs will continue for 1 more year. Prime Minister will continue for 1 more year. The government will continue for 1 more year. Getting my point, right? But you can do it 1 year at a time. From 5 years, you cannot extend it to 8 years. You can. How? 5 to 6 years. Once your 6 years term is over, still emergency is in operation, continue for 1 more year. 6 to 7.
Gradually,
yeah, if there is emergency in existence, you can continue only when there is emergency in existence. You can continue for 1 more year. In next year, if there is no emergency, you cannot continue. If there is emergency, national emergency is in operation in the country, then you can continue for 1 more year. Like that, 1 year at a time for any length of time. If there is emergency for 10 years, you can continue for 1 year, 1 year, 1 year, like that for 10 years. Got it? And it says that, but this extension will not continue 6 months after the emergency has ceased to operate. Okay? Once the emergency is over, after that, till 6 months the extension can go. Before that, you should conduct the election. That 6 months time is given for you to conduct the elections. You conduct the elections and bring in the new government within 6 months. Yeah. Once the emergency is over, elections must happen to the house. Clear? Same not only for parliament, Lok Sabha, also for state legislative assembly also, the term can be extended. During 1974, when national emergency was imposed, the term was extended once a year. Elections were supposed to happen in, I think in 75, they extended it for 1 year. Like that. Okay, they extended. It can be extended. Okay? Clear? Fine. Then, effects on fundamental rights. Effects of national emergency on fundamental rights. Okay. There are 2 articles that deals with two articles that deals with suspension of fundamental rights during national emergency. Okay, one is 358, other one is 359. 358 and other one is 359. 358 and other one is 359. Article 358 deals with suspension of fundamental rights under Article 90. Article 358 deals with suspension of fundamental rights under Article 90. Article 359 deals with all other except 20 and 21. Okay. Article 358 deals with suspension of fundamental rights under Article 90. Whereas Article 359 deals with suspension of all other fundamental rights except 20 and 21. Right? What do you mean by Article 19? Six rights. Right to freedom of freedom is complete rights. 19 to 22. What is 19? Speech and expression, assembly, association, movement, residence, profession. Speech and expression, assembly, association, movement, residence, profession. There are six rights which are protected under Article 19. Article 19. What Article 358 says? It deals with suspension of fundamental rights when national emergency is in force. Article 358, just listen, right on it. Article 358, what it says is, if there is national emergency in the country, okay, your fundamental rights under Article 19 are automatically suspended.
19 is suspended.
Then it means that you don't have Article 19. Speech and expression, assembly, association, movement, residence, profession is not there. The government can impose laws, can bring in laws that can curtail your Article 19. Got the difference? Got the meaning, right? When the national emergency is in force in the country, then your Article 358 says Article 19 is suspended. I'll come to that. Article 358 deals with only Article 19. Okay? Article 19. Your speech and expression, assembly, association, movement, residence, profession can be restricted. Means the state can bring laws. State matlab, this the parliament can bring laws that can restrict your fundamental rights under Article 19. Your speech and expression can be curtailed. There can be a restriction for you to move. Profession, assembly, association. Right? And second thing, under this article only, for suspending Article 19, the government need not to bring in any separate order. Once the national emergency is imposed, automatically Article 19 is suspended. There is no need of bringing in any separate order of president. The moment Article 352 is imposed in the country, Article 19 is 352, no? 352 is national emergency. The moment Article 352, that is national emergency, is imposed in the country, Article 358 will be automatically applicable. Means 352 and 358 are together. The moment 352 is imposed, 358 is applicable automatically. Your Article 19 is suspended. There is no separate order for the suspension of the fundamental rights. Second thing, it is applicable only during war or external aggression. National emergency is imposed on the grounds of war or external aggression. During internal disturbance, Article 358 is not applicable. Okay? During internal disturbance, 358 is not applicable. Only during war or external aggression. Okay? Understood now? Article 358 related to suspension of fundamental rights under Article 19 during national emergency. And it is applicable only during war or national emergency is imposed on the grounds of war or external aggression, and there is no need of any separate order of president for suspension of the fundamental rights. The moment Article 352 is imposed, Article 19 is automatically suspended. Any laws made by Parliament, you cannot challenge in the court of law stating that it is violating the Article 19. If any laws are brought in during emergency, if it is violating the Article 19, you cannot challenge in the court of law. Okay. So next is Article 359. Article 359 deals with all other fundamental rights except suspension of all fundamental rights except 20 and 21. What do you mean by 20?
Protection of conversion and offense.
I'll finish this topic and I'll leave. You can write the question now then. Then I'll have to start president rule. 15 minutes is enough now for you guys. 5 more minutes. I'll finish this. Then 10 minutes you can write the question. Okay. So Article 20 is right against conviction for offences. No double jeopardy, no ex post facto law, no self incrimination. Right? Article 21 is right, personal life. Right to life and personal liberty. Right to life and right to life and personal liberty. So what Article 359 says is it related to suspension of all the fundamental rights, but it is not applicable to 21. 20 and 21, even if there is a national emergency in our country, then 20 and 21 can never be suspended. Right? It is a universal right. It can never be suspended. Have I told you while doing fundamental rights, the rights available only to Indians and rights available to foreigners? No? Just write them there. 15, 16, 19, 29 and 30 available only to Indians. 15, 16, 19, 15, 16, 19, 29 and 30 available only to Indians. 15, 16, 19, 29 and 30. 15, 16, 19, 29 and 30. Available, these are all the fundamental rights available to only Indians. Other fundamental rights are available to both citizens as well as non-citizens. Okay. See, yeah. So your 20 and 21 can never be suspended. One more thing, see, when national emergency is imposed, here not actually your fundamental rights are violated, are not taken back. Article 359 is your right to approach the court. Right to approach the court for their enforcement is actually violated, is taken back, is suspended. What the difference? No. It doesn't mean that there is no right to equality when there is a national emergency. But you cannot go to court of law if your right to equality is violated. Getting my point, right? And the difference I am speaking, when there is Article 359, if there is a national emergency, Article 359 is not automatically applied. Only those fundamental rights which are mentioned in the presidential order will be suspended. Getting my point, right? The president can issue orders stating that only 14, 15, 16 are suspended. Got the difference, no? Under Article 359, if president issue an order stating that only 14, 15, 16 are suspended, then only those fundamental rights are suspended. Article 358, what it says, when there is a national emergency is imposed in the country, Article 19 is automatically suspended. But Article 359 deals with other fundamental rights, but those rights are not suspended actually. Right? Only those fundamental rights which are mentioned in the presidential order are suspended. President can suspend all the fundamental rights except 20 and 21. Okay? He can suspend all, or he can suspend only 15, 16, 18, that's all. Or 25, 26, 27, 28. Whatever mentioned in the presidential order, only those fundamental rights will be suspended. Got the difference, right? Only those fundamental rights are suspended which are mentioned in the presidential order. Here, actually the fundamental rights are not suspended. Your right to approach the court for the enforcement is suspended. Right? When there is no fundamental, means when national emergency is enforced, you cannot go to court and say that my fundamental rights are violated. Effectively, Article 32 is suspended. Correct? No. Article 32 gives you a right to approach the court of law if your fundamental rights are violated. Here you cannot approach the court. So effectively Article 32 is suspended. Clear? Fine. Got the difference between these two, no? Article 358 automatically suspends the fundamental right. 359 does not suspend the fundamental right automatically, where President has to issue a separate order. For 358, President need not issue a separate order. President issues an order of Article 352, that is national emergency, then 358 will automatically apply. But 359, President has to issue an order stating that these are all the fundamental rights which are suspended. Then only those fundamental rights will be suspended. Clear? Got it? No? This is about effects of fundamental rights, effects of national emergency on fundamental rights. Okay. Next we have to do state emergency, that is President's rule, and financial emergency. We'll do it tomorrow. You can write the test. 10 minutes. So tomorrow we will write test or day after tomorrow? Tomorrow.